Remember that time that a court found that AR-15s are not legally firearms and that the ATF cannot regulate them? I remember that time. And at the end of this video, you're going to be able to tell people you remember that time too. My name's Tom Grieve, ex-state prosecutor, criminal defense attorney. Guys, let's get into it. So we are in Ohio. The time is 2019. The case is U.S. versus Rowold. R-O-W-O-L-D for those of you on your lawnmower. So Mr. Rowold was found to be in possession of 15 AR-15 lower receivers. I know, what a crime. Basically, he's charged for being in possession of a firearm as a result of being in possession of the 15 AR-15 lower receivers. Now, why that was a crime for him, kind of irrelevant because we're focused on whether or not those lower receivers themselves are a firearm. So for those of you who are new to the Second Amendment and new to this, the AR-15, first off, does not stand for assault rifle. It's Armalite Rifle, the company that invented it, 15 being the 15th iteration of the different prototypes and designs. It's basically a two-part system comprised of an upper receiver and a lower receiver. Neither the upper nor the lower receiver can, standing alone by itself, cause the weapon to fire. The upper receiver houses the bolt and enables the insertion of the barrel. The lower receiver provides housing for the hammer and the firing mechanism. An AR-15 lower receiver, that's the part designated to be a firearm by the ATF, is basically nothing more than a container that would, in a completely assembled firearm, house only two things: the hammer and the firing mechanism. Yeah, it hosts the stock and the grip and all that kind of stuff too, but we're talking about for legal definitions of what makes it a firearm or not: hammer and the firing mechanism. Now, this is important because the Gun Control Act of 1968 defines a firearm as A, any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by action of an explosive. B, the frame or receiver of any such weapon. C, any firearm muffler or firearm silencer. Or D, any destructive device. So we're obviously focused on specifically A and B, and most specifically B, the frame or receiver of any such weapon. Because after all, an AR-15 lower receiver unto itself is certainly not capable of being readily converted. It's going to take a little bit more to readily convert that. So we're really focused on this as being the frame or the receiver. In our particular case, the receiver, because receivers go to long arms, frames go to handguns. Now, this is, again, important because the statute does not itself define what is a frame or a receiver. That being the case, that's where the Bureau of Alcohol, Tobacco, Firearms, and Explosives, otherwise known as the ATF, adopted a gap-filling regulation that defines the term frame or receiver as, quote, that part of a firearm which provides housing for the hammer, bolt, or breech lock and firing mechanism. Now, it's very important how the commas work here. Hammer, that's number one. Number two, the bolt or breech lock. And number three, the firing mechanism, and which is usually threaded at its forward portion to receive the barrel. You can find that in the Federal Register at 27, section 478.11. Let's add this together now. Does the lower receiver of an AR-15 house the hammer? Yes. Does it house the firing mechanism? In other words, the trigger? Yes. Does it house the bolt or breech lock? No. It's also not usually, or really ever, threaded at its forward position to receive the barrel. So we have an important problem. Congress did not give us a definition of what constitutes a frame or receiver, and the only definition we have comes from the ATF, who, by their own definition, an AR-15 lower receiver is not a firearm because it's not a lawful receiver, which makes it a firearm. Nor, by itself, is the upper receiver. Where does that leave us? It leaves us with the legal argument that an AR-15, this isn't legally a firearm, at least not those parts. The upper or lower receiver are not lawful firearms under this argument. Now, obviously, if you put the whole thing together, then there's an argument for the fact that we're checking the first one, that this is any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by action of an explosive. So if you put the whole firearm together and, it's a firearm that fires bullets. Now we're talking about something that it's a firearm. But if you break it down, it doesn't neatly fit this definition. And that's what the arguments were in court to push back on this, when the defense filed a motion to dismiss, saying, look, these lower receivers, these hunks of metal, these hunks of aluminum, usually aluminum, sometimes carbon fiber or something else, but typically aluminum, these are not receivers under the ATF's own definition. Now, the government replied to that by arguing that you have to throw out this motion to dismiss in light of the fact that the ATF has consistently applied its regulations to bring AR-15 low receivers within the Gun Control Act. In other words, Judge, look, you have to throw this out because we've always done it this way. Yes, the rule says this, but we've always done it this way. So come on, right? But there is no limitations period in this situation. Judge wrote, quote, misapplying the law for a long time provides no immunity from scrutiny, end quote. Now, the judge went on to note that the Supreme Court has already provided the answer to this type of argument. Quote, if a violation of a regulation, which is what we have here, subjects private parties to criminal or civil sanctions, they all virtually do, a regulation cannot be construed to mean what an agency intended but did not adequately express. Nor, will I add, has the government shown that either the Chevron or the Auer deferences require a contrary result. So we're getting a little law nerdy here. Basically, those are arguments saying that, look, Chevron deference, we should allow administrative agencies to basically enforce and interpret their own interpretations of government statutes, of congressionally passed laws, okay? But the judge responds to that by saying its demand for deference ignores the directive that, quote, if uncertainty does not exist, there is no plausible reason for deference, end quote. So what the judge is saying is, look, Chevron, Auer, these things apply if there's uncertainty, if there's some sort of ambiguity as to how we should interpret and apply a particular administrative rule and interpretation. The judge is saying there's no ambiguity here because the rule stands on its face, and an AR-15 so-called lower receiver, it's not a receiver, and nor is the upper. And the judge pointed out that deference to agency interpretation in a situation where the regulation is unambiguous. In other words, if you let the agency interpret something or reinterpret it, more like, when there's no ambiguity here, that would, quote, permit the agency under the guise of interpreting a regulation to create a de facto, a new regulation. And we can't do that. Guys, if you're liking this video, be sure to show your support for not only this channel, but as well as the Second Amendment by hitting that like button. And also, I look forward to seeing you on the comment field below as well. Be sure to stick around to the very end for our quote of the day. If an agency wants to roll the dice and try to propose a new rule and go for it, then go for it. As long as you're not overstepping the bounds of the Administrative Procedures Act, the APA, the Constitution, and so forth, then yes, you are free to go ahead and make your new interpretations. But if we're just going to be allowed to continuously interpret and reinterpret without changing the words, we've got major issues here. And the judge throws the flag and says no. And the judge goes on to point out why this isn't his problem or fault. It's not like the court just stumbled onto this problem or invented it. Per a 1971 Internal Revenue Service memorandum, which, as a reminder, was the precursor to the ATF at the time, quote, apparently the M16 receiver is fabricated in two parts, and the Enforcement Division has determined that the lower portion should be considered the receiver. We were assured at the time that the lower portion comes closer to meeting the definition of frame or receiver in the implementing regulations, although both parts were necessary to function as a frame or receiver. I can see some difficulty in trying to make cases against persons possessing only the lower part of the receiver, but insofar as the licensing, serial numbering, and special occupational tax requirements are concerned, I feel that this is the only practical solution, end quote. So again, that's the precursor to the ATF saying, yeah, this has problems. And this is something that the new frame receiver rule, which is going through court right now, does address this issue by going into what is called the split frame or receiver expanded interpretation. And perhaps, by the way, this is what the Fifth Circuit was going on about when they recently decided that, look, we're not going to strike down the whole rule that the ATF passed in its entirety, but instead maybe we're just going to carve out, and they sent it down to the district court, the district trial court, to maybe only strike down those sections that expand the definition of what a firearm is into those primordial ooze states. In other words, yeah, that hunk of plastic, if you have the right jigs, suddenly that's going to be a firearm. I'm guessing, connecting the dots, that this is where we're going to wind up with this. But in any event, and per that video that I did covering the recent Vanderstock v. Garland decision, the rule remains in effect for now, and I do anticipate that this will probably so-called be the fix for the AR-15 receiver issue and split-frame receiver firearms, which, by the way, includes things like SIG 320s and also arguably hammerless guns. Because keep in mind, the congressional statute dealt with hammered fired guns. Does that mean that striker fired guns are not covered by the Gun Control Act? There seems to be an argument for that. So all that winds up getting lumped in and resolved by the new ATF rule, like it or hate it. And I think that that's where it's going to basically fix all that. At the end of the day, does that mean that as of right now, AR-15 lower receivers are unregulated? No, because the U.S. Supreme Court stepped in and basically said, look, until they've had a chance to weigh in again, this rule remains in effect. So the Supreme Court basically saved the ATF on this for drafting some horrible different rules, well, not only now, but of course over the years. And that's something, of course, to think about. The ATF left open a door for about 40 plus years that in essence deregulated AR-15s as non-firearms, as well as many of the nation's top-selling pistols and other striker-fired firearms arguably as well. Now, this may come as news for some of you, but maybe the government, especially the ATF, isn't so perfect, right? Our quote of the day comes from noted Roman speaker Seneca: "While we wait for life, life passes." I hope you have a great day. Don't forget to hit that like button, show your support for the Second Amendment. I look forward to joining you in the discussion in the comment field below. And as always, I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.